Hi, this is Dr. Hart. So let's get into this. Burwell versus Hobby Lobby, 2014, one of the most important cases decided during the second decade of the 21st century. What is the significance of the case? First, it extends freedom of religion through the Supreme Court's application of the RFRA, Religious Freedom Restoration Act, to secular artificial persons such as privately held for-profit corporations. Okay. Second, the case showcases the power of business interests even before the appointments to the Supreme Court made by Donald Trump. So the court we see in this particular case demonstrates its pro-business slant. Number three, the decision is limited to the application of the RFRA. So this case does not answer the question whether privately held for-profit corporations are protected by the Free Exercise Clause. So this is just a RFRA case. What are the facts? The Green family owns and operates Hobby Lobby stores, and that's a national arts and crafts chain with over 500 stores and over 13,000 employees by the time that this case reaches the Supreme Court. The Green family has organized its business around principles of the Christian faith and has explicitly expressed the desire to run the company according to biblical precepts, one of which is the belief that the use of contraception is in fact immoral. So that's their belief, the belief of the Green family. Under the Patient Protection and Affordable Care Act, or ACA, colloquially known as Obamacare, employment-based group healthcare plans must provide certain types of preventive care, such as FDA-approved contraceptive methods. While there are exemptions available for religious employers and nonprofit religious institutions, there are no exemptions available for-profit institutions like Hobby Lobby stores. So in September of 2012, the Greens, as representatives of Hobby Lobby, sued Kathleen Sebelius, the Secretary of the Department of Health and Human Services, and basically challenged the contraception requirement. The Green family argued that the requirement that the employment-based group healthcare plan cover contraception violated the Free Exercise Clause of the First Amendment and the Religious Freedom Restoration Act of 1993. The plaintiffs sought a preliminary injunction to prevent the enforcement of tax penalties, which the district court denied, and a two-judge panel of the U.S. Court of Appeals for the 10th Circuit affirmed. So the Supreme Court also denied relief, and the plaintiffs filed for an en banc hearing on the Court of Appeals. The en banc panel of the Court of Appeals reversed and held that the corporations were persons for the purposes of RFRA and had protected rights under the Free Exercise Clause of the First Amendment. So the question for the Supreme Court of the United States was, does the Religious Freedom Restoration Act of 1993 allow for-profit companies to deny their employees health coverage of contraception to which the employees would otherwise be entitled, based on the religious objections of the company's owners? So by this point, Sylvia Burwell had replaced Kathleen Sebelius as Secretary of Health and Human Services, which is why her name is in this case. What was the ruling of the Supreme Court of the United States? In the opinion authored by Justice Samuel Alito, the court held that Congress intended for the RFRA to be read as applying to corporations, since they're composed of individuals who use them to achieve desired ends. Because the contraception requirement forces religious corporations to fund what they consider abortion, which goes against their stated religious principles, or to face significant fines, it created a substantial burden that is not the least restrictive method of satisfying the government's interests. In fact, a less restrictive method exists in the form of Department of Health and Human Services exemption for nonprofit religious organizations, which the court held can and should be applied to for-profit corporations like Hobby Lobby. Additionally, the court held that this ruling only applies to the contraceptive mandate in question rather than to all possible objections to the Affordable Care Act on religious grounds, as the principal dissent fears. So what the court said was RFRA established a strict scrutiny standard for laws that seek to interfere with religious liberty. And in order to overcome strict scrutiny, government must have a compelling purpose, and it also must use narrowly tailored means. That is to say, the least restrictive means to interfere with fundamental liberties like freedom of religion. And the court said that in this case, government did not use the least restrictive means. In plain English, what the court is saying is Hobby Lobby and other privately held businesses like it, where you cannot separate between the individuals who run the store and the store itself. You cannot separate between individual owners and the company that they hold, that they run. Then an exemption is necessary for religious liberty to be protected. In his concurring opinion, Justice Kennedy wrote that the government had not met its burden to show that there was a meaningful difference between nonprofit religious institutions and for-profit religious corporations under the RFRA, right? So while we all understand that there is a conceptual difference between religious institutions like churches, temples, synagogues on one hand, and for-profit corporations, but what does this have to do with RFRA? RFRA does not, according to Justice Kennedy, differentiate between these two types of artificial persons. So because the contraception requirement accommodates the former, meaning religious institutions, and imposes more restrictive requirement on the latter without showing proper cause, the requirement violates RFRA. In her dissent, Justice Ginsburg argued that for-profit corporations cannot be considered religious entities. So according to her, they should be excluded from religious liberty protections. And that's basically the case. Once again, an important case which shows the ascending power of religious protection. It shows that the court in the 21st century does go a long way in protecting religious liberty, and that the RFRA did in fact have its intended effect, that the federal government used it to bind itself to a higher standard of protection. Strict scrutiny is required, and according to the majority, this was a 5-4 decision. Strict scrutiny was not satisfied in this case because the means used to implement government's policy were not narrowly tailored to the purpose. Thanks for your attention.